Good afternoon, everybody, and welcome to the first of our webinars here from Thomson Reuters Roundhall in Dublin. My name is Pamela Moran. I'm the publisher with Roundhall, and I'm delighted to be joined here today by two guest speakers. Dr. Robert Clark is consultant to Arthur Cox and the author of our leading text, Contract Law in Ireland, which has just published in its 8th edition. And Dr. John Breslin is partner at Maples and Calder and author of our well-known banking law text, which is currently being updated with a view to publishing a 4th edition in 2017. During today's webinar, we will be bringing you up to date on important changes in the areas of penalty clauses and illegal contracts, focusing specifically on contractual clauses providing for default interest. During our discussion of the main principles in this area, we will also touch on some relevant case law and recent decisions in Ireland, the UK and Australia. Before we proceed, a couple of housekeeping points. If you experience any technical difficulties with this session, please message the producer using the Q&A panel. Secondly, as a reminder, this event is being recorded for rebroadcast. And finally, we encourage you to submit questions at any time during the presentation using the Q&A panel located on your screen. Type the questions in the space provided, hit the send button, and please make sure you direct your questions to all panelists in the Ask menu. Time permitting, we will try to address some or all of your questions at the end of the session. So firstly, I would like to turn to you, Robert, and ask you to open the session by taking us through illegal contracts and their historical introduction.
Thank you, Pamela. This is Robert Clark speaking. The session will break into 3 parts. I will speak generally for about 7 or 8 minutes about the background to illegal contracts, looking at the cases that have been decided in several jurisdictions. Then John Breslin will take over and he will talk specifically to the main issue here, which is the impact of the recent Quinn decision in the Supreme Court. And he will be addressing a regulatory fault issue. Then I will close the session with some comments about recent developments in relation to penalty clauses. So to begin, the historical introduction that I would put to you is quite a straightforward one. Here, the question of illegality in contract is dealt with by case law in the main, and the public policy can be based on an overwhelming desire, which holds fairly true, that there is a desire to make sure that the legal system is not used to subvert the administration of justice. So if people are suspected of being able to get away with illegal conduct, then the legal system will be held in contempt by the majority of citizens. And this is a very important goal. The source of the invalidity may be generally from one of 2 directions. There could be a common law or some ethical or moral imperative that needs to be upheld, or there could be a statutory provision, a statutory rule, which tries to regulate conduct. And of course, in contemporary society, these regulatory rules are increasing and more likely to be the basis upon which the issue of illegality appears in litigation. There are 2 basic rules. First of all, that no disgraceful thing will ground a cause of action. And secondly, when the position of the parties is one in which they are equally at fault, the law will simply wash its hands of the transaction and step to one side and leave the loss to lie where it falls. There's a tendency, however, to change this approach, particularly in cases of statutory illegality, and it's given nothing away to say that in more contemporary times there is a more liberal assessment taken of parliamentary intention, and the importance of alternative remedies such as restitution is becoming an increasingly important area of the law. Now, just to give you a flavour of just how rapidly this area is moving, there are a number of cases here from the UK House of Lords, the UK Supreme Court, in which the actual outcome perhaps is, in some cases, rather surprising. The first is Hunger and Allen from 2014, in which the House of Lords had to deal with the question about whether a woman who had been used as an unpaid labourer in a domestic context, she knew that the employment was illegal, she participated in the illegality, but the circumstances were such that this woman was unfortunately trapped in what amounted to modern slavery circumstances. And there the Supreme Court said, yes, this person is involved in this transaction, knows that the transaction is illegal, but the circumstances were such that the illegality of the claimant in this context was clearly much more minimal than that of the other party. Second case is the Le Laboratoire case, in which there was a defence to a claim which consisted of, well, you can't recover effectively on this claim because there was an infringement of a Canadian patent. And in this case, the House of Lords basically took the view, here we have another case where regulatory overspill has moved criminal law into the area of civil remedies for intellectual property rights. Intellectual properties are increasingly being buttressed by criminal law, and I think it's no understatement to say that really all that happened here was the court said, look, enough already, we have a broad range of civil remedies, there's no need to allow the criminal law to spill over here and taint what is otherwise a fairly ordinary IP dispute which has taken place for over 100 years. The two later cases, A.L. Barnes and Tinsley and Milligan, are really quite remarkable decisions because until fairly recently, Tinsley and Milligan was a case which the English courts and indeed the English Law Reform Commission was trying to build its entire policy around. A.L. Barnes and Moore Stevens was a decision given recently in 2009. But the remarkable thing about these two cases is that they are now persona non grata in terms of judicial circles. Lord Neuberger basically said of those two cases, I hope I never hear of them again, and if they're ever pleaded before the UK Supreme Court, we'll take absolutely no notice of those decisions. Irish cases are also interesting, but perhaps not as, with the exception of the Quinn case, not quite as dynamic as the English cases, but to be fair, at least they're not so inconsistent in terms of that general direction of travel. Hortensis and Bishop is an interesting statute law case here where there was a transaction, a loan transaction. There was a dispute about whether the loan transaction was legal or not in terms of the bank actually having the necessary permissions to do that, to actually issue the loan. And there were problems here, but really the court was able to say, well, we have this doctrine in English law which says that where you have a fault in a transaction, but the transaction is carried into effect, the fact that it may be a void transaction can be repaired by the transaction being carried into operation. So the illegality can be cured. But note again, this is a regulatory breach. It's not a breach of some overwhelmingly important moral or social imperative. The two other cases on this PowerPoint slide here are of interest. The first, which is the General Thema case, shows up the fact that even in the space of 1 year, two different judges will take a different view on how the law is to develop. In this case, it was really a dispute about whether the old offences and torts of champity and maintenance should effectively be consigned to the dustbin or at least read in more contemporary circles. And there was a very strong disagreement between High Court and Court of Appeal and again the High Court in those cases. The more fun case on the slide, however, is Ennis and Butterley, which I'm sure would be well known to you. This is a case in which the High Court took a fairly conservative view of transactions between persons who are cohabiting and whether in that context they can enter into contractual arrangements which will affect their property rights and their interests. There's always been a very strong view that the sanctity of marriage is something that should not be subverted by people being able to cohabit and effectively get all the trappings of marriage without having to go through the ceremony of the same. And contrast with the New South Wales case of Ashton and Pratt, in which the New South Wales Court of Appeal dealt with a transaction involving two people who effectively agreed as between each other. The man was a billionaire, he said to a friend of his, a very attractive young lady apparently. I've seen her on the websites. By the way, the position of mistress is now open. So this was clearly a very difficult situation to reconcile with the more traditional view of sexual mores. And in this case, the New South Wales Court of Appeal was able to sidestep it by saying, well, I'm sorry, the transaction's too vague or too ambiguous to actually constitute a contract. So they managed to avoid that important point. The Australian cases are particularly influential in this area. And I'll refer you to, I think, three cases that, again, very much in summary, show the way in which the Irish courts and indeed even the UK Supreme Court have engaged with these cases. Remember, we started by saying that the real issue for regulatory illegality is that these transactions are often complex. They're often morally ambiguous in the sense that we don't know who's actually consciously breaking the law. So none of the old common law illegality cases are all that relevant. But the tendency here is to adopt a much more nuanced approach, which John will pick up on in relation to the Quinn case. The first is an old case now. It's Yango Pastoral against First Chicago. And this was a case in which a bank gave a mortgage. The bank gave the mortgage to the borrower. The bank was an unlicensed body, needed to have a license. More importantly, the bank was committing an offence, and there was a fixed penalty of a payment per day for each day that the unlicensed lending was taking place. This was not a collateral transaction. It was a fairly important and central transaction, but in the case, the High Court of Australia, the biggest appellate court, largest appellate court, said, we think that where there is a plea of statutory illegality, that in effect, where the statute lays down a sophisticated set of rules and penalties, the impact of the common law in importing into that transaction common law principles should be tempered or at least relaxed somewhat. So if there's a statutory scheme, go with the statutory scheme. Marsted Services in Ketchell is similarly a case in which there was a regulatory failure. It was a licensing transaction in which the license was given to a franchisee. The franchisee was entitled to certain statements by way of information. This wasn't forthcoming, and the licensee nevertheless tried to recover the monies that were due under the transaction. The licensor, the franchisor, was slow to make the payments and claimed that there was a statutory illegality. Again, the court took a very important approach to this, very important benchmark, saying this legislation is there to protect franchisees, licensees. It would be ludicrous to view the law as giving the party who was there to be protected under the statute no rights on the basis of a technical infraction by someone else to this transaction. So again, a very straightforward but very sensible approach to this. And finally, Gnitch and Polish Club is also an important case because it deals with the issue of whether breach of licensing conditions in terms of rules intended to provide that fit and proper persons are the only persons that actually run hotels and bars. There, the High Court of Australia said, well, again, we've got an important policy objective, but again, the statute is clear. It sets out that there is a regulator. It sets out powers for the regulator, that the regulator can operate. It makes no sense to import into complex statutory law a set of common law provisions that will subvert the legislative purpose. And that's the approach that we're increasingly going to find. That's all I want to say at this time, so I'll just transfer now to John Breslin, who will take up the theme of illegality.
Thanks, Bob. So the starting point, and I suppose the central question I'm going to look at is whether a regulatory breach, in particular by an authorised bank or financial institution, is going to prevent that institution from insisting on its legal rights. In other words, does this doctrine that Bob has outlined operate so as to deprive, for example, a lender of its rights to sue for the recovery of a debt that is due? And in looking at this issue, it's worthwhile looking back a little bit to where we've come from, in the sense that the doctrine that Bob has outlined, which is that the court will not allow itself to be used as a means of perpetuating an illegal act. One of the earliest cases was from 1725, where two highway robbers were engaged in civil litigation concerning a dispute over the division over the proceeds of their crimes, literally. And such was the affront to the court that the court said, first of all, it wasn't going to grant a remedy, and even went so far as to issue arrest warrants for the plaintiff's solicitors. And again, in the 18th century, the basic principle was articulated that this doctrine of illegality is not really there to do justice between the parties. It's there to preserve the integrity of the legal system. So that's the overall backdrop to this issue. One of the recurring themes in the two cases I'm going to look at is a recognition that things have moved along very considerably from the 18th and 19th centuries. We live in a highly regulated era. There are very few areas of commercial activity which are not subject to some form of statutory regulation. And the best example of that, I suppose, is the financial services industry and the banking industry. And if we look at banks in particular, in terms of their lending activities, they're subject to different layers of regulation. Much of it is highly technical and all pervasive. So a bank will be subject to particular requirements under the Consumer Credit Act when it is lending money to consumers. Banks are also subject to very technical regulation coming from the European Union to do with their governance and capital requirements. And as regards how the banks interface with their customers, they're subject to central bank codes of practice and more recently statutory rules written by the central bank under the Central Bank Supervision and Enforcement Act of 2013. So it's probably worthwhile pausing and asking in practical terms what sort of issues can cause a problem for banks in particular that would require them to evaluate their situation under the doctrine of illegality. And there are three obvious examples which derive from consumer lending transactions and in particular requirements under the Consumer Credit Act. And as I'm sure many of you will know, the Consumer Credit Act requires lenders to have information clearly spelled out on contractual documents, information such as the cost of credit, the annual percentage rate of charge, and other very basic data in relation to consumer credit transactions. Another complication for banks is that if a loan goes into default and the bank is minded to recover the loan or enforce its rights, it has to give the consumer a grace period to allow him or her to remedy the default. And if that grace period is not observed, then there are going to be problems for the bank. Then there's the basic issue which Bob touched on in discussing the Yango pastoral case from Australia. This is where an institution has entered into a lending transaction and does not have the appropriate statutory authorization or license. That's less of an issue for banks, obviously, but in an era where alternative lending is becoming more prevalent, it's an issue which is going to become very live, I'm sure. So how has this issue been dealt with in the past? Well, there have been three broad approaches taken in the past. First of all, there's the old traditional approach, which, as Bob has outlined, is for the court to simply wash its hands of the situation, let the loss lie where it falls, and effectively to abstain, stand back and leave the parties where they are. That was an approach which was prevalent up until around the middle of the 20th century, when that approach evolved into a notion that a court would refuse to enforce a party's contractual rights where this would, quote, shock the conscience of the court, unquote. And that was a formula which continued up until one of the English cases that Bob mentioned, namely Tinsley versus Milligan. A key criticism of that approach has been that it effectively amounts to the exercise of a judicial discretion. In other words, whether the court grants a remedy is really to do with the visceral reaction of the judge to the fact scenario, and for that reason, that doctrine has pretty much fallen by the wayside. It was replaced with a slightly more scientific approach, which was to ask whether the party looking to enforce its rights has to rely on the illegality in order to bring home its claim. So the question there is the illegality central to the claim, or does it merely form part of the backdrop? So what are the key developments here? The important developments are two decisions, one of the Irish Supreme Court in Quinn versus IBRC, and the second is a slightly later decision of the UK Supreme Court in a case called Patel versus Mirza. So looking at the Quinn versus IBRC decision first, this was a complicated case, very complicated facts, but in brief, this was the trial of a preliminary issue, so it wasn't a full hearing with oral evidence. But the High Court directed that a discrete issue of law should be tried before the main action, and it effectively concerned charges over shares and other securities such as guarantees given by the Quinn family as security for loans by the bank that was formerly known as Anglo-Irish Bank Corporation. And Anglo had made loans to the Quinn companies. Now, just pausing there for a moment, the fact that this is a case on a preliminary issue is an important point to note, because what the court had to do there was to look at the issues on the assumption that what the plaintiffs, that's the Quinn family, was saying were true. And what they were saying was that the loans were given by Anglo to the Quinn Group companies in order to allow the Quinn Group companies and their controller to buy shares in Anglo. And there was an allegation that Anglo was effectively trying to prop up its share price on the stock exchange. So the court didn't find one way or the other whether those allegations were true or not, but because it was trial of a preliminary issue, it had to proceed on the basis that those allegations would be made out. But the essential question was, if those allegations were brought home, did it mean that Anglo, now known as IBRC, could not enforce its security? So in very brief terms, did the supposed fact that these loans were given for an illegal purpose, was that going to prevent Anglo from suing on its security? And as I'm sure you're aware, the loans on that allegation would have been illegal because a company is not allowed to give financial assistance for the purchase of its own shares. And also, had the allegations been true, very likely they would have breached the EU regulations on market abuse. So what emerged from this preliminary issue was obviously a High Court judgment which went against IBRC, who then appealed to the Supreme Court, and the Supreme Court reversed the High Court. And the court's judgment was handed down by Mr. Justice Clark. It's a very sophisticated and nuanced analysis of the issue. It's a very significant case as well, because it surveys not only Irish law but also many of the Australian and UK authorities, which Bob has mentioned. So what was the conclusion? Well, the conclusion of the Supreme Court was that even if the transactions did breach the Companies Act's rules on financial assistance, and even if they did breach the EU market abuse regulations, that would not prevent IBRC from enforcing its legal rights under the security documentation. And the analysis of the Supreme Court is, as I said, very sophisticated and very nuanced. But in brief, it is as follows. First of all, when you're looking at this issue, you have to look at what the statute, which renders the conduct illegal, provides. And that is really the key starting point for the analysis. So if the statute provides expressly that if a particular provision is breached, then the party in breach is deprived of legal rights, then that's the end of the analysis. You do what the statute tells you. As many of you are aware, very few Irish statutes actually spell out the civil law consequences of a breach or even a criminal offence created under the statute. So in those circumstances, then the statute isn't going to give you a clear express answer. So you've got to then apply these other formulae. And the next one is that the court will take into account and apply considerable weight to the fact that the conduct has been deemed to be illegal by the statute. And so the illegality will be a significant factor in how the court determines the civil law rights of the parties. Then the court will look at the overall statutory policy and ask itself how that policy is going to be impacted if it does grant a remedy to the party in breach. In other words, will the policy be undermined or will it not be adversely affected at all? And as part of that analysis, it will look at the impact on third parties. And as Bob alluded to, if the statute is there to protect a particular class of customer or third party, then that will inform the court's reaction. Therefore, if withholding a remedy is going to injure third parties, then that's a strong suggestion that the court should grant a remedy. But it will look at the class of person that the statute is designed to protect. And this was a significant factor in the Quinn case, because part of the Supreme Court's analysis was that if the court did not give a remedy to the bank, then that would adversely affect the interests of the bank's shareholders or shareholder, and the court held that could not have been intended by the legislature. So that, in its broad outline, is the approach which will be taken. It's a very sophisticated approach. I've just summarised it. It has a number of other elements, but at the end of the day, in the Quinn case, the court looked at the Companies Acts and the EU regime on market abuse, and noted that there were already in the legislation precise provisions which dealt with the civil consequences of a breach of the relevant provisions. It also took note of the not insignificant penalties which the legislation provided for, and in this regard it picked up on a theme which was very strong in the Australian case law, in particular Yango Pastoral, that if the legislature has gone to the pain of spelling out precise consequences of a breach in the statute, then a court should be very slow to add to those consequences by withholding or refusing a remedy. So that's the Quinn case. The next case I want to briefly look at is the decision of the UK Supreme Court in Mirza versus Patel. This was a judgment about a year after the Irish Supreme Court's decision in Quinn. The facts of that case were pretty straightforward. The plaintiff, or the claimant, had paid £620,000 to the defendant with a view to the defendant receiving inside information with regard to the shares of a bank which was listed on the London Stock Exchange, and it was envisaged that the plaintiff's money would be used to trade on inside information. As you all know, inside information is a criminal offence. The deal or the transaction did not go ahead because apparently the inside information did not emerge, or it could not be used. The defendant had allegedly paid the £620,000 to a third party who didn't pay the money back to the defendant. So when the plaintiff asked for his £620,000 back, the defendant wasn't able to return it, and so the plaintiff brought an action, amongst other things, for restitution of his £620,000. So just pausing there for a moment, insider trading is a very serious criminal offence. We spoke a few minutes ago about the case from 1725 involving the two highway robbers. Well, this in some respects could be viewed as the modern equivalent, but we see what happened. The case was heard by 9 judges of the Supreme Court, and they were unanimous in holding that the plaintiff was entitled to restitution of his £620,000. And as far as I'm aware, they didn't issue an arrest warrant for the plaintiff's solicitors either. So we've got a very different outcome to the 1725 case. But what is really significant from the decision is that the 9 judges of the UK Supreme Court were very sharply divided in their different analysis. There were basically 2 schools of thought in the Supreme Court. A majority, with the leading judgment of Lord Toulson, favoured a policy-based approach to solving the problem of what rights does a party acting in breach of the law have. Again, this approach was based on a detailed analysis of the legislative policy outlawing the relevant conduct. And I think there are distinct similarities between the approach taken by Lord Toulson and others and that taken by the Supreme Court in Mr. Justice Clarke's decision in Quinn, although the Quinn case was not mentioned in any of the judgments in Mirza against Patel, and I don't think was mentioned in argument either. But the approach of the majority in Mirza is similar to the approach in Quinn. So we're seeing the legal approach between Ireland and the United Kingdom being broadly aligned in that regard. A minority leading judgment of Lord Sumption and also Lord Mance were still in favour of the reliance-based test. In other words, you would allow the claim if the party acting illegally was not relying on his or her own illegal conduct. Lord Sumption disfavoured the policy-based approach because, in his view, it was very close to exercising a judicial discretion. But in any event, the outcome was that the claimant was entitled to restitution of the money he had paid, which was intended for insider dealing. And it's perhaps significant that the remedy given was restitution. It wasn't based on any claim and contract. It was the return of monies by which the recipient was unjustly enriched. And that may really explain in legal terms the difference between the outcome in 1725 and the outcome in 2016, where we have a developed law of restitution. So going on to the central question here, does a regulatory breach bar a claim by a bank or a financial institution in breach of the law? This is still a very difficult question for practitioners, but considerably more clear thanks to the decision of the Supreme Court in Quinn. The answer is going to be one which depends on the statute. You look at the statute and find out what it can tell you about what the consequences are going to be. If it's clear from the statute that a party acting in breach of a particular provision has no rights, then that's the end of the matter. Likely you're going to have to go a stage further and look at the policy of the statute and ask yourself, is the policy of the statute going to be subverted or damaged if the claim is allowed? But the overall message, I think, is that there seems to be a new spirit of the age or zeitgeist, and that is that there appears to be, in broad terms, more judicial tolerance of parties in breach suing to enforce rights, and that comes about from an entrenched recognition now that we live in a highly regulated era, and that regulatory breaches can come about inadvertently rather than for any malicious purpose. So I'll finish my piece by drawing your attention to a case which only came to light after we'd prepared the slides, and it's a decision of Mr. Justice Toomey in the High Court in a case called English versus O'Driscoll and others, and it's a judgment handed down on the 25th of October 2016. this was a claim in professional negligence in the context of a tax-based capital allowances scheme, and basically the plaintiff was suing an accountant for failing to obtain an independent valuation of the assets which were the basis of the tax scheme. The judge, of his own motion, raised the issue of illegality because it became apparent to him at the end of the hearing that the scheme was one which perpetrated effectively a fraud on the Irish revenue, and he sought argument on that particular issue, which he had raised. None of the parties had raised it. The defendant certainly didn't raise it. And it's an interesting decision because Mr. Justice Toomey analyses the transaction in considerable detail and concludes that it was an illegal transaction, and he basically threw out the claim. So it underlines that illegality is something which can be raised either by the parties or by the tribunal itself. So that case is English against O'Driscoll, and is handed down on the 25th of October of this year. So over to you, Bob. Thanks.
Thank you, John. Ladies and gentlemen, as you see, we've kind of gone a little bit further in terms of time than we intended to. So I was planning on giving you a quick run through on the recent developments in relation to penalty clauses. You're now going to get an even quicker run through the decisions. So I've provided a number of slides which should allow you to, as they say, self-guide yourself through this, but I'll give you a heads up on this. Law on penalty clauses has been in a state of some flux for about 10 to 12 years, both in England and in Ireland. You will be aware that historically the test of whether a clause was a penalty or was liquidated damages. If it's a penalty, then it isn't enforceable. If it's liquidated damages, then the clause will take effect. Has been a matter of judicial statement, principally by Lord Dunedin in 1914, where he said this is really all a matter of interpretation. The parties might label a clause as being damages, but if we think that in substance it's one of a penalty, then we will not allow this to take place. And the argument was that a clause which is a penalty is one in which the party who is extracting a performance from the other uses the threat of a payment of monies, normally in terrorem, over the head of the other party to make sure that that other party doesn't breach the contract. Now, there are 4 rules that deal with this, and I'm only going to give you one of them, and it's the principal rule, namely, if the clause, let's say, is for if you fail to do X, then you will have to pay 100,000 euros by way of compensation. If the breach that takes place, even under the worst case scenario, is only going to lead to damages of 10,000, then that will not be a genuine pre-estimate of the loss, and the clause will be struck down as being a penalty. So these rules, which evolved through case law, are there, and they've been well settled since 1914. There's much learning in the 2 more recent decisions, the El Makdassi case, which is the recent Supreme Court of the UK decision, and Pasioko, which is a decision of the High Court of Australia from, I think, July 2016. And both the judges' panels in both cases go through the legal history of the evolution dealing with penal bonds and all kinds of other arcane areas of legal history. However, in an aside, the Chief Justice of Australia said, well, it's all very well looking at English legal history. This is all really great stuff. But at the end of the day, this should really be about statutory interpretation. And he also took a swipe at the fact that the UK Supreme Court keeps talking about the English common law, whereas the Australians are much happy to talk about English common law, and also they say our statute now as an Australian common law. So it's all very interesting pitching really between the two courts. Okay, let's move on and deal with the more recent decisions. There's been a movement away from the Dunedin rules, these 4 rules which are really looked at by judges after 1914 as if they were holy writ. There have been movements away in a number of cases involving finance transactions where judges have said these rules are not rules in the sense that they are inflexible and intractable. They're benchmarks, and now they're described by judges in England and Ireland and indeed in Australia as being simply benchmarks which, amongst other things, can be taken into account in deciding whether public policy is offended by this particular penalty. Perhaps the most important case, although it's only a High Court case, is a decision from Mr. Justice Coleman in 1996, which is the Lordsville case, which involves one of the areas that has been litigated on considerably in recent times, namely when, for example, a borrower defaults on a loan, what happens if the contract provides for penalty interest? Can this be enforceable, or is it a penalty in the sense that it's not a genuine pre-estimate of the loss? And in Lordsville, Justice Coleman moved away from the old approach, looking at the 4 rules found in Dunedin's approach, and basically moved towards the idea that, yes, there is a possibility that this payment that is due, or this obligation that has to be met, may be described as a penalty, but does it have some overweening commercial justification, which will allow a court to decide that the clause in question should be upheld? Lordsville is interesting because there what the judge laid down was a basic rule of thumb. If you default on the loan, and if the loan then provides you're going to have to pay 3% or 4% more by way of penalty interest, if the clause has retrospective effect, in other words, it boosts the amount of money that's going to have to be paid, then that's going to be a penalty. Now, later cases also deal with situations where the clause does not have retrospective effect, but ultimately the courts have got to decide whether the standard clause, which ups the payment upon breach, is one which has to be met. So there have been a number of cases in Ireland, and they start really with ACC Bank against Friends First, where there were problems about a penalty clause which said you default an extra 6%. Second case on this is AIB and Fahy, which is a fortiori. You default, the interest goes up to 12%. And Sheehan and Brescia, which is the most recent decision, you default, it goes up by 4%. Now, in all of those cases, the court effectively said, this is not a genuine pre-estimate of loss. Show us the commercial justification for this. And in these cases, the court was given submissions to say, well, you've got to bear in mind that if we default, there are a number of consequences. Our liquidity loading has to go up. We are now dealing with impaired loans. Our reputation suffers. These are all things that need to be borne in mind. But in these cases, the Irish High Court has been consistent and said, well, that's not enough. We need to have some assurance that this is a genuine mechanism. Now, if I can fast forward to the most recent Australian decision, which is not a banking case in the sense that those Irish cases are, in Passi Oko, the situation was slightly different insofar as this was a consumer who found that under the terms of his lending transactions with his bank, he was to pay a sum of money if he was overdrawn, let's say. But if he failed to pay that sum of money, there was another loading, which would be arguably a genuine pre-estimate of the loss that took place. Now, rather like those Irish cases, and I urge you to read Pasioko with those decisions that I've mentioned, there the court really said, okay, yes, the party who has to plead that this is an illegal contract has to prove it, has to satisfy the court. The burden of proof is there, but we're still going to have to require some assurance, some explanation as to why, objectively speaking, it's necessary to load extra payments into this transaction. And in these cases, the court was able to say, well, we're not satisfied on the proof. In the Australian decision, there were important evidentiary points, because what the High Court of Australia was persuaded by was statements, well, somebody defaults on a loan, judge, there are other costs that are involved. We have loss of provision costs, we have regulatory capital costs, and we've got to collect extra. So this justifies this additional topping up of the amounts. But I think what's really important here was, if you think about those cases of bank defaults, the bank default cases are all ones where the party was a developer, the economy changed, there wasn't really anything they could do about it. The important point about that Australian case is that in the High Court of Australia, there was a statement from several judges who said, well, this borrower here doesn't have to borrow. This borrower here is using the extra monies, the extra movement that's given by the late payment fee to actually regulate the way in which he or she wishes to borrow money. So it might be convenient for 1 month simply to pay it, and maybe inconvenient the other. So there isn't the degree of coercion. There isn't any interorum aspect to this. So they're very, very interesting balances between those cases. Now, I'm conscious of time, and I think it's probably as well if I simply conclude here. If you look at the last slide that I have here in relation to the key issue as it appears in the El Makdassi case is this. The onus of showing that the payment which is being demanded under the terms of the contract is the onus of proof lies on the complainant, the person who's making the payment or suffering the detriment. And really what the High Court of Australia would agree with was the same basic test. Is the payment provision, which is a collateral payment provision, which is triggered by a breach, a failure to make the payment in this case, is it out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation? So although we don't look at interorum and all of that 19th century language, it is very much a balancing mechanism. You default, that's your primary obligation. That triggers secondary obligations. Is the secondary obligation to make the payment or lose property rights, as in El Makdassi? Is this grossly disproportionate? Is it out of all proportion to the legitimate interest that the bank could put forward in a banking transaction, such as making sure that liquidity ratios are not prejudiced by wholesale defaults by bank customers? Thank you very much, ladies and gentlemen.
Okay, fantastic. Thank you so much, Robert, and thank you, John, for that. I think we probably could have gone here for a couple of hours if we'd had the time, but we don't want to keep you too long over the allotted time. I would like to take a couple of questions, if it's okay with you both, that have just come in here during the session. John, you might take the first one for me, please. I'm just going to read it out here. The question is, in a situation where, for example, a lender's documentation is defective under the Consumer Credit Act, does it follow that the lender's claim for repayment will be successful under the new approach?
Well, I think that's probably a helpful example, because the Consumer Credit Act is one of the few bits of legislation where, in parts, it does spell out what the consequences of a breach are. So, in very brief terms, if the lender has failed to give a copy of the contract and the guarantee, if there is one, to the borrower and the guarantor within 10 days, then the Act says then any claim on the contract or the guarantee is unenforceable. So that's the end of the matter. If there's a breach of some of the other information requirements, for example, the requirement to set out the APR, then the lender is going to have to go to court to get an order that it can enforce the contract, and it will get that order provided it can show that the breach was inadvertent and it's just and equitable to allow the claim.
Okay, thank you, John. Robert, I'm going to ask you one of our questions here, please, if I might, before we go. So the question is, there are some draft clauses that I'm hoping to draft so as to impose financial penalties on the other side if the contract is breached or terminated. What can I do now to maximise the chances that the clauses will not be held to be penalties in terms of any future litigation that might result?
Okay, the first thing to note, that question talks about clauses being used in order to try and compel performance, and it's in the context of two different things. One is the question of breach, if you breach this contract. The other is if you terminate the contract. Under Irish law, and the jury is still out on this, it's not at all clear that the rules relating to penalties apply to termination clauses, such as terminating a hire purchase agreement. And the English courts tend towards a strict view saying penalties only apply in relation to termination on breach clauses, not termination clauses simpliciter. So I'd try and look at that and factor that into your drafting. The other thing, as I mentioned there, is that the situation is a little bit fluid. We know that the party who's trying to characterize the payment obligation as a penalty has the evidentiary and the onus of proof placed upon him or her. So you will have to show that this comes within the rules relating to penalties. However, bear in mind, and I've made this point in the presentation, I'm sorry it was so rushed, but bear in mind that this is all going to be about evidence. And one of the important things that you will really need to do is to document just why you have that requirement. Why is that clause there? So to go back to the banking cases, in the Irish cases, the decision was that there was insufficient evidence which would justify upholding this requirement to pay extra money. But could you document that? Can you make it clear why that clause is in there as a matter of commercial expediency? Also, bear in mind that when you are drafting these agreements, the loss is only going to come to light, the breach is only going to occur, the termination is only going to occur probably some months, if not years ahead. So you will need to have some kind of paper trail, if only to prove to the court that there was a clear commercial justification. So perhaps you need to think about getting some kind of evidence there in terms of a consultancy or an accountant who will explain why in particular you've got that clause in there and what its commercial purpose is, in order to persuade the court that even though the burden of proof might be on the other side, you're improving the case by saying it's important to note that this clause is in here for this reason, Judge.
Great, thank you, Robert. Okay, I think we're going to leave it there then for today. It only remains for me to thank both Robert and John for participating in the webinar with us this afternoon. I hope that you have found it useful if you're listening in. Many thanks for all of the questions. If you did submit a question today that we haven't had time to address, we will endeavour to get back to you at a later date. So from all of us here in Roundhall and from our speakers, thank you and good afternoon.